Mr Deputy Speaker, I rise today as a non-Aboriginal person and as an independent member of this Legislative Assembly to speak to this matter of definite public importance, the failure of the Finocchiaro government to maintain and uphold the Northern Territory's critical system for the protection of Aboriginal sacred sites. And I thank the member for Mulka for bringing this matter to the chamber today, and I thank the member for Gwoja for so passionately outlining how this actually impacts on Aboriginal people, the people that we're all here to represent. This failure strikes at the heart of our integrity as a jurisdiction. It undermines the rule of law because it signals that those with economic power can disregard the law with impunity, while those charged with upholding it are left without support. And it betrays the promise of the Northern Territory Aboriginal Sacred Sites Act 1989, a statute that has long stood as one of the most important recognitions of Aboriginal law and belief in Australia. The Sacred Sites Act is not just another piece of environmental regulation, it's a foundational law of recognition. It acknowledges that Aboriginal people are the traditional owners and custodians of their country, and that the protection of sacred sites is integral to the maintenance of their law, of their culture and their identity. The Sacred Sites Act also forms part of a suite of laws designed to benefit Aboriginal people and includes the Aboriginal Land Rights Act, the NT's companion legislation, the Aboriginal Land Act 1978, the Heritage Act 2011 and the Native Title Act. These laws not only assist all of us by recognising Aboriginal Territorians' enduring relationship with land, ensuring their legal ownership and control over country, protecting their cultural and spiritual heritage, they also provide a framework through which development in the Northern Territory can proceed with certainty, without controversy and with a social licence. The Act is grounded in Section 73(1)A of the Aboriginal Land Rights Act 1976, which gives this territory the power and responsibility to legislate for the protection of sacred sites. It does so through the Independent Aboriginal Areas Protection Authority, a statutory body at arm's length from government with clear duties to consult, issue authority certificates and enforce compliance. Mr Deputy Speaker, that independence is its strength. That independence provides the all-important certainty for developers and custodians alike. And it is that independence which this government has systematically undermined. In May this year, Acting Judge Stephen Ledeck handed down a judgment in the Vista Gold case, Australia prosecution, a case that should have been a line in the sand. Vista Gold pleaded guilty to damaging a sacred site near Leyland Edith Falls on Jawoyn country while conducting drilling operations at the Mount Todd mine. 12 drill holes were sunk within a restricted works area, an area the company knew was sacred and where they were prohibited from drilling. In his sentencing remarks, Acting Judge Stephen Ledeck described Vista Gold's conduct as nothing more than a mercenary exercise where they had been looking for what they believed was there, but unfortunately found it to be under a restricted works area. He said the offence was driven by everything to do with the price of gold and noted that the fine of $160,000 was insignificant compared to the company's projected profit of more than $500 million. Mr Deputy Speaker, that is not the failure of the Aboriginal Areas Protection Authority. That is a failure of political will. The authority did its job, it investigated, prosecuted and secured a conviction. But when the judiciary itself tells us that the penalties are insignificant, it's the government's job to respond. Instead, the CLP government has been busy weakening the very framework that allows the ARPA to protect sacred sites in the first place. These changes were pushed through no matter what the Minister says without genuine consultation. Traditional owners, the Northern Land Council, the Central Land Council and the Aboriginal Areas Protection Authority itself raised alarm. The amendments neither streamline nor modernise the Sacred Sites Act. They serve a single purpose, to permit one politically convenient project, the Waterfront Hotel, despite Larrakia opposition grounded in the protection of a registered sacred site. I'm told that the rush of applications predicted by the CLP to justify these changes has not occurred and can be counted on one hand. The NLC described the bill as a rush job that undermines the integrity of sacred site protection in favour of developers. The CLC said the government treated us like children. And, Madam Speaker, they were right. By allowing certificates to be transferred or altered after issue, the government has opened the door to regulatory manipulation. It's created conditions where a proponent can obtain a certificate for one purpose and later repurpose it for another without renewed custodial consent. And by introducing enforceable undertakings as an alternative to prosecution, the government risks turning the protection of sacred sites into a private negotiation between developers and bureaucrats, rather than a matter of public accountability under law. This is not reform, this is regression. And Madam Speaker, perhaps the most serious failure is this government's systematic erosion of the Aboriginal Area Protection Authority's independence. The ARPA is a statutory authority, it's not a branch of government. It was designed that way to protect it from political interference so that it could stand firm in upholding Aboriginal law even when development pressures mount. For more than 40 years, it's managed and mediated the intersection of Aboriginal cultural responsibilities and the Territory's development ambitions. Every major project, every road, every piece of public infrastructure and every mine has been considered by the authority. The vast majority of those projects have proceeded without any controversy because of ARPA's work in facilitating agreements that respect sacred sites and support responsible development. Only a small number of matters ever reach public attention, and that is a mark of the authority's effectiveness. The ARPA has quietly managed complexity into outcomes that balance cultural protection with progress, and the Northern Territory should be proud of this institution. Yet the CLP government has treated the authority as a political inconvenience. It's refused to support the organisation with adequate funding despite the growing complexity of projects such as Sun Cable, Arrows, onshore gas in the Beetaloo Basin and the Darwin Waterfront Hotel development. It's steadily undermined the authority's standing by reshaping the legislative framework in ways that erode its independence and bring key functions closer to ministerial control. Rather than strengthening the authority, as the Minister just said, this government has weakened it and in doing so weakened public confidence in the protection of sacred sites. We all understand the Territory needs development, we need investment, we need jobs, we need infrastructure, but responsible development is not the same as reckless development. Responsible development requires proper, respectful consultation with traditional owners, proper respect for cultural authority and Aboriginal law, transparent and enforceable conditions on all certificates, and a government willing to stand up for cultural heritage even when it is politically inconvenient. The CLP government's actions send the opposite message. They tell the world that sacred sites are negotiable and that culture is an obstacle, not a value. That approach undermines not only Aboriginal people, but the credibility of the Northern Territory as a responsible place to do business. We know that investors crave certainty and integrity. They want to know that when approvals are granted, they are lawful, defensible and grounded in respect. And when this government erodes the independence of the ARPA and politicises the Sacred Sites Act, we invite risk, we invite controversy and we invite distrust. This pattern of disregard did not start with Vista Gold. We saw it in the Gunlom Falls case where the Federal Court and later the High Court found that the Director of National Parks had breached the Sacred Sites Act by authorising works that had desecrated a sacred site. That case was a triumph for the rule of law and for the authority's integrity, but it also exposed the chronic vulnerability of sacred site protection when government agencies themselves fail to comply. And now, under this government, that vulnerability has been codified into policy. Instead of strengthening the system in the wake of Gunlom, the government has chosen to weaken it. As an independent member of this Assembly, I say clearly the protection of sacred sites should not be the plaything of politics. It should be the cornerstone of our legislative integrity. An independent, properly funded and professionally supported ARPA should be a source of pride for every Territorian. It embodies the principle that development in the Territory must occur under two laws, Aboriginal law and Australian law, working together, not in conflict. Every day in this chamber, we hear the member for Mulka saying, work with me. Every day he puts that invitation to people in this chamber. Madam Speaker, this is not support, this is sabotage. If we are serious about responsible development, this government must act now to restore proper funding to the ARPA and guarantee its independence. It must review the penalty regime under the Act so that fines deter rather than reward corporate risk-taking. It must reinstate genuine consultation processes with land councils and traditional owners. It must amend the Act to reverse the recent changes that have weakened protections and commit to full transparency in decision-making so that every authority certificate and condition is open to public scrutiny. Madam Speaker, these are not partisan objectives, they are essential steps to rebuild trust and uphold the Territory's reputation for fair and responsible governance. Madam Speaker, this government has failed to support the authority, it's failed to uphold the spirit and letter of the Sacred Sites Act, it's failed to protect the cultural and spiritual heritage of this Territory, and has failed to show respect to Aboriginal Territorians, including those here in this chamber. In the Vista Gold case, the judge told us plainly the fine was insignificant and the conduct was mercenary. That judgment should have prompted legislative action. Instead, this government used its majority to make things worse. Madam Speaker, sacred sites are not an inconvenience to be managed. They are the living heart of Aboriginal culture and, by extension, the living heart of this place that we call the Northern Territory. To weaken their protection is to wound the Territory itself. Madam Speaker, I once again thank the member for Mulka for bringing this important matter of public importance to the House. And I say that it's time to restore integrity and to restore respect and put protection before profit and law before politics. Madam Speaker, I commend this matter to the House.